When considering custody arrangements, or that being the parenting time, the amount of time that a child will spend with one or the other parent, and parental responsibilities, the responsibility for each parent to make decisions on behalf of the child and to work together to make those decisions. Courts, in considering whether that parenting time should be equal or whether that decision making should be joint or should be separated between the parents, consider a wide variety of factors. As we've discussed, those factors really do all boil down to the best interest of the child. But when you break it out, really what the court is looking at is a variety of factors that help it determine that standard. One that sort of stands out all the time is the willingness and the ability of each parent to promote a positive relationship between the child and the other parent. That is, quite honestly, in the beginning of a divorce case, sometimes one of the hardest hurdles to overcome is to get our clients and to get the other side to both try to promote a positive relationship between the children and the other parent. Except in circumstances of abuse or something like that, that is truly often in the child's best interest. Other factors that the court might consider is the environment that each party can provide to the child, the willingness to set their own lives aside to promote the education, to promote the well-being, to promote the extracurricular activities, to promote all the aspects of the child's life, to put the child first. Is each parent willing? Is each parent able to do that? These are among the highest factors that a court will consider. When the court encounters a parent who's more focused on their own life, who's more focused on promoting their own well-being, is more focused on promoting their next relationship, the court might have questions about their willingness to promote the best interest of the child. And so these are factors that the court considers. One thing that we run into a lot is, will the court consider the fact that parent A is able to provide the child with a more beautiful house and a swimming pool or a better neighborhood than parent B? And those are things that we often caution people about. The court is not going to pay much attention to. The court is going to insist that the child have a safe and sanitary place to be, where the child can continue to grow and thrive. But that disparity between the parents' financial abilities to provide for the children will be equalized with child support, but will not typically greatly affect parenting time. One thing people wonder is how each parent's relationship with the child or children affects custody. And, offhand, you might think the answer would be a lot. That a parent who's having a challenging time with their child would be less likely to be awarded the equal parenting time. But that's generally not the case. Parents have difficult times with their children for a variety of reasons, some of which are completely developmentally appropriate. There are just times when relationships between children and parents can become challenging. And the courts don't look to those as factors in determining when or where the parenting time should be. Where the relationship is challenged because of things that are not developmentally appropriate, that's where the court might take another look, because that is when the parenting relationship might be being affected by something that is not in the child's best interest, where the parent is promoting their own interests above the child, and that is causing a rift in the relationship. Very often, if the court is concerned that that might be the case, the court will employ a child and family investigator or a CFI, or ask that a PRE or even a child legal representative be appointed in the case to help advise the court as to what the problem might be and whether that should impact the award of parenting time as to the parent that's having the challenges. The mental and physical health of a parent can have some effect on parenting time, in the same way that everything else we've discussed can have an effect on parenting time. And that is the mental health, is the physical health of the parent affecting the parent's ability to promote the best interests of the child? Are these challenges or difficulties that the parent's going through, or that are permanent, do they affect substantially that parent's ability to provide a safe place for the child, to give the child the support and upbringing that the child needs, to be a stable and loving parent, and to promote a healthy relationship between the child and the other parent? To the extent that the physical or mental health of the parent does affect those things, that might affect parenting time for a temporary amount of time or even a longer amount of time, depending on that parent's willingness and ability to overcome those disabilities and focus on promoting the best interests of the child, even above their own. A lot of parents want to know about the child's preference and how that affects custody decisions or parenting time decisions or decision-making decisions. And, that answer is one of the more challenging. There are states that have presumptive ages of where the child reaches a certain age. The child's decision is determinative or at least presumptive, meaning if the child chooses parent X, then the child is with parent X unless the court determines that is not in the child's best interest. That is not the case in Colorado. The best interest of the child test lasts through majority, through the child becoming emancipated and being no longer a minor child of the marriage or of the parents. I think there's some both legal and quite honestly pragmatic things to consider. If anybody has tried to tell a 16 or a 17-year-old where they're going to be against their will, they will probably sympathize with why that might be a challenging thing for courts to implement as well. What the courts will look to is that the parents are promoting the best interest of the child and not trying to win the child from one to the other or putting the child in the middle of the conflict. The courts will look very, very unhappily towards that. But as the child reaches beyond the age of reason, the courts are likely to listen and to take the child's preferences into consideration along with all the other facts and circumstances. And quite honestly, I think it's fair to presume that the court will consider it not to be in the child's best interest to be forced to live somewhere they don't want to. And in that way, the child's interests become more and more important in the best interests of the child standard as the child ages towards majority. In Colorado, how do the courts look at parental involvement when deciding parenting time? And that's often a challenging factor to work with parents on. Very often we'll be working with parents in a circumstance where prior to the divorce or prior to the parents not effectively co-parenting voluntarily, one parent will say he or she, the other parent, was never there, didn't really pay attention to the kids, wasn't a big part of their lives, and therefore should be shut out from their life for all time to come. And that is not how things tend to work out. The decisions that the parents made during the course of a marriage or when they were living close or living together as to how they divided up childcare are not determinative of how the childcare will go for the rest of the child's life. It is more the consideration of the willingness and the ability of each parent to be an effective and present parent now that the family circumstance has changed. They are not latched forever to the way that things were. Everything's changing. That being said, a parent who then continues to not exercise parenting time, continues to be an absentee parent, continues to put their needs in front of the child's, will likely be demonstrating to the court that they are not the one to promote the best interest of the child and could face a reduction in their parenting time.